Assalamualaikum warahmatullahi wabarakatuh. I bid to my respected lecturer, Dr. SASLINA binti KAMARUDDIN, and my fellow friends. So for today, we are going to present about our topic, which is meetings. We are from group 11. Okay, this is our team member of group 11, which consists of 6 people. Firstly is Julia, ZAQWAN, me myself, ASNA, AMIRUL SHAHMI, Nurul Syafwanie, and AHMAD FARRIS.
What is meeting and its purposes? Generally, meeting is defined as a gathering of 2 or more persons. Company meeting is where resolutions are passed and the company management, administration, direction, and business are determined. It serves as the check and balance against the director's power and to ensure that their duties and responsibilities are discharged accordingly. Company meeting has its limitation, and this limitation can be defined under the Sharp cases. So, in Sharp versus Dex 1876, it defined that the meeting refers to a coming together of more than one person. In these cases, actually, a single shareholder purport to hold a meeting to pass a resolution to make calls. The meeting was scheduled for 30 December and only 2 people attend. The 2 people was Sharp as the company secretary and Silverside's a member. The latter act as chairman while the former took minutes. The meeting resolved that the calls be made, but the defendant member declined and was sued. It was held that no meeting had been properly constituted and the purported proceedings were null and void. The case is authority for the proposition that one person cannot constitute a meeting or a corporate assembly. However, in Company Act 2016, the Act recognized a meeting of a single person. In the meetings, there are 3 relevant sections, which are, the first is Section 9 of the Company Act 2016, which in this section is the essential requirement of a company stated that a company shall have a name or one or more members having limited or unlimited liability for the obligation of the company. And this section also stated that a company shall have, in the case of a company limited by share, 1 or more shares, and a company shall have 1 or more directors. This section 9 of Company Act 2016 merely provides that a company shall have 1 or more members. To provide for a meeting of a sole member, the Company Act 2016 enacted the Section 344, which applies to all sole member companies. In this Section 344, subsection 1 stated that if a sole member of a company takes any decision that may be taken by the company in meetings of members and has effect as if agreed by the company in meeting of member, he shall provide the company with details of the decision unless the decision is taken by way of a written resolution. In subsection 2, stated that a person who contravenes this section 344 commits an offence and shall, on conviction, be liable to a fine not exceeding 10,000 ringgit. Subsection 3 of Section 344 stated that failure to comply with this section does not affect the validity of any decision referred to in subsection 1. Actually, this section 344, it provides that the sole member may either pass a written resolution or provide the company with details of his decision. This will be the same as the decision taken away by the company in a meeting of members, and the effect as if it was agreed by the company in a meeting of members. The third relevant section for meeting is Section 333 of Company Act 2016. This section is a representation of corporation at meetings of members. Subsection 1 of Section 333 stated that if a corporation is a member of a company, the corporation may, by resolution of its board or other governing body, authorize a person to act as its representatives or representatives at any meeting of members of the company. Next, the subsection 2 of Section 333 of Company Act 2016 stated that if the corporation authorizes only one person, the person shall be entitled to exercise the same powers on behalf of the corporation as the corporation could exercise if he was an individual member of the company. It is then submitted that the corporation, which is the sole member, may then represented by its corporate representative, who is entitled to exercise the power as the corporate shareholder. Subsection 3 of Section 333 of Company Act 2016 stated that if the corporation authorizes more than one person as its representative, every one of the representative is entitled to exercise the same powers on behalf of the corporation as the corporation could exercise if every one of the representative was an individual member of the company. Next, the subsection 4 of Section 333 stated that if the corporation authorizes more than one person and more than 1% of the representative purport to exercise the power under subsection 3, if the representative purport to exercise the power in the same way, the power is treated as exercised in that way. Or if the representative do not purport to exercise the power in the same way, the power is treated as not exercised. Subsection 5 stated that a certificate of authorization by the corporation shall be prima facie evidence of the appointment or the representative or the revocation of the appointment, as the case may be of a representative under this section. If all the shares of a particular class in a company are held by only one person, a meeting of the class may be held by the attendance of the sole member of the class. Next is the place of meeting. The location are designed by the board for the purpose of holding a meeting.
Next, I would like to explain about the types of meeting. There's two types of meeting, which is AGM, Annual Grand Meeting, and EGM, Extraordinary General Meeting, that will be explained by my friend ASNA. So, let's talk about the AGM, Annual Grand Meeting. So, it is written under Section 304 of Companies Act 2016, which states that every public company shall hold an AGM in every calendar year, in addition with other meetings that have or will be held during the period. So for the purpose of this, the AGM shall meet this requirement, which is first, must be held within 6 months of the company financial year, and the second one is the AGM shall not more than 15 months after the last proceeding of the AGM. However, you must listen on this. However, the company shall not be required to hold a general meeting AGM in the year of its incorporation or in the following year, provided that the company hold its first annual grand meeting within 18 months of its incorporation.
Okay, my name is ASNA AYUNI bin JEPRE, so I will explain about Extraordinary General Meeting, or it's called EGM. It is all general meeting of a company other than statutory and annual general meeting. These meetings are called in emergency to discuss some urgent special business that cannot be postponed till the next annual general meeting. So, who is convened in EGM? So, the first is the board of director, second, members, and the three is the national company law, which or we call is court, by the court. For board of directors, under section 310A, the board of directors can convene a members meeting. Section 3161, notice required to be given for a members meeting of a private company and is minimum of 14 days or longer based on the company constitution. Section 3162B, notice required to be given for members meeting of public company, but and also minimum is 14 days or longer based on company constitution. And last, section 2921, the notice not less than 21 days must be given to all members if the company for passing a special resolution. The powers of members to convene meeting. Under section 310B, any members that have 10% of issued share capital or minimum 5% in the number of members if the company has not share capital can convene a members meeting. Safari Alliance and Berhad versus Tiger Synergy Berhad cases, they have a reverse duty on the company director to inadvertently call another general meeting of competitor on the date period to the meeting that has been called. That is because make confusion to shareholders. The calling of such meeting except for urgent reason shall be deemed improper and therefore void. So the power to require director to convene of the meeting. Under section 3111, the member of the company can require the directors to convene a members meeting. Under section 3113, the director will be call the members meeting when the company receives requisition from two conditions, which is first is member with minimum 10% of the paid up capital, and the second is member who hold at least 5% of total voting rights. And under section 3121, the director shall call the meeting required within 14 days from the date of requisition, and they can hold the meeting on a date not more than 28 days after the date of notice. Okay, under the court, under section 3142, the court may by its own motion or made by 3%, which is the first is directors, members, and personal representative. And under section 3141, power of court to the meeting will be applied when the director and members is impracticable to have the meeting. Under section 3143, when the court makes such order, the court may provide consequentially direction which the court deemed expanded. And under section 3144, the meeting may have one member of the company to be present at the meeting. In the case of court, under Real Noel Statement Holdings, which is the first, in this case, the only shareholder who are also director of the two companies were killed in an accident, leaving an infant child behind. So the court held that the test or whether the provision can be applied in that is applicable only when there is no practicable means of calling a meeting. So the court have power to convene the meeting because of the director and members is held in accident.
Next, I will talk about the power of members to convene meeting by court order. Okay, here's the situation. For a company without a share capital, or we can call it as a company limited by guarantee, an EGM, extraordinary general meeting, may be convened by at least 5% of its member. And in certain situation, the court also have the power to convene a meeting. But ZAQWAN, what is the situation and how the court may decide to have a meeting by the power of the court. Okay, here's the situation. So if there's an occasion where there's a particular of director would like to call for an EGM, extraordinary general meeting, to discuss an urgent matter, but however the intention of the meeting does not been shared to the other directors. So he may then, the first director just now, he may then apply to the court under section 314 of the Companies Act 2016 to call for an EGM. Just now we have talked about the power of members to convene meeting by court order. Okay, on this section, we are going to go through the section 314 under the Companies Act 2016, which the power of court to order for a meeting. Okay, for this section, it applies that if any reason it is impracticable to call for a meeting of members of a company in any manner in which meetings of the company may be called. Or the second one is to conduct the meeting in the manner prescribed by the Constitution or this Act. Usually, application is made under section 314 when it is impracticable or impossible to convene an EGM as prescribed by the company's constitution or in the CA 2016. Okay, we have understand the concept of section 314 under Companies Act 2016. Okay, let's see some cases that are related to this topic. Okay, for the cases is the Real Sawam Reno Limited on 1958, where there are three shareholders, shareholder A, shareholder B, and shareholder C. For the shareholder A and shareholder B, each of them carry 5% each of the issued capital, and the balance is owned by the shareholder C. And then the shareholder A and shareholder B are frustrated on shareholder C because the shareholder C attempts to get rid them from the company. Okay, and with that attempt, the shareholder C has applied to the call for a meeting, and the court has ordered for a meeting by the power of the court.
Publication of notice of meetings on websites. Section 302 subsection 1, notice of a meeting of members shall not be validity given by a company by means of a website unless a notification to the effect is given in accordance with this section. Section 302 subsection 2, the company shall notify a member of the notice on their website, and such notification shall be in writing and shall be given in hard copy or electronic form stating A. that is concerned a meeting of members, B. the place, date and time of the meeting, and C. in the case of a public company, whether the meeting is an annual general meeting. Section 302 subsection 3 stated, there shall be made available on the website throughout the period of the beginning from the date of the notification referred to in subsection 2 until the conclusion of the meeting. Person entitled to receive notice of meetings of members. Section 321 subsection 1, notice of a meeting of members shall be given to every member, director and auditor of the company. Section 3021 subsection 2, it includes any person who is entitled to share in consequences to death or bankruptcy of a member would be entitled to receive notice of the meeting, and the company has been notified of the person's entitlement. Method of notice to be given. Section 319 subsection 1, it shall be in writing and given to the members either in hard copy, electronic form or partly in both form. In subsection 2A, it shall be sent to any member either personally or by post to the address supplied by the member to the company for such purpose. In subsection 2B, it shall be transmitted to the electronic address provided by the member to the company for such purpose or by publishing on a website.
Next, I would like to talk about the period for notice of the meeting. As you all know, there's two types of company, which is public company and private company. Okay, so let's see what is the period for the notice of the meeting. Firstly, for the meeting of the members for a private company, it is written under section 316 subsection 1 of the CA 2016. A meeting of members of a private company or other than a meeting for the passing of a special resolution shall be called by notice at least for 14 days or any longer period specified on its constitution. The next one is the meeting of members of a public company, which is written on the CA 2016 under section 316 subsection 2. A meeting of a members of a public company, other than a meeting for the passing of the special resolution, shall be called by a notice. First, in the case of the annual general meeting, at least 21 days or any longer period specified in its constitution, and in other cases, at least 14 days or any longer period specified in the constitution. And last but not least is the AGM of a public company. Under section 316, subsection 3. We said that an annual grand meeting may be called by a notice shorter than a period referred in the subsection 2 if agreed by all the members entitled to attend and vote at the meeting.
Proceedings at meetings. Meetings of members at 2 or more venues. Section 3 to 7 subsection 1. Subject to the Constitution, a company may convene a meeting of members at more than one venue using any technology or method that enables the members to participate and exercise the members' rights to speak and vote at the meeting. The main venue shall be at Malaysia and the chairperson shall be present at that main venue of the meeting. Quorum is the minimum number of members who must be present at the meeting. Section 3 to 8, subsection 1. In the case of a company having only one member personally present at a meeting shall constitute a quorum. Subsection 2. In any other case, 2 members personally present at a meeting or by proxy shall be a quorum unless a higher number is specified in the Constitution. Referring to the example case law of Poltis and another versus Plastico Limited 1967, it was held that a purported meeting by the only surviving shareholder was void because the regulation required 2 members to form a quorum.
Okay, next let's continue with the proxy. A proxy is a person who has been authorized by a member to attend the meeting on his behalf, which means that's a person who represents a member in the shareholders meeting of a company with a legal document that could prove their authorities. For example, corporate representative, where the member is a corporation, it can attend the members meeting only through its representative. Okay, next. Section 334, Subsection 3, Companies Act 2016 lays out the statutory requirements in the appointment of a proxy. Now, any members can appoint anyone to become his proxy at a company's meeting. The most important is for the members who wish to appoint a proxy to comply with the appointment procedure under this section. This is to avoid a situation where an appointed proxy vote in contradiction to the wishes of the appointing shareholder or to ensuring that the intention of the appointing shareholder is reflected in the voting process. Next is under section 294 subsection 2 B and section 334 subsection 2, no maximum numbers of the proxy, which means that there is also no maximum number of proxy that can be appointed by a members. If a member appoint more than one proxy, under this section states that the requirement for the members to specify the proportionate numbers of shareholdings intended to be represented by each proxy. Next is method of appointment. A member who wish to appoint a proxy signs the instruments of appointment. Second, the duty signed instrument is to be deposited at the company's registered office or at such place in Malaysia specified in the notice of the meeting. Third, the time frame to deposit the instrument is not less than 48 hours before the meetings. And the last one is, if the proxy is to vote on all, then the time frame to deposit the instruments of appointment is not less than 24 hours before the time appointed for the taking of the poll. Otherwise, the proxy forms may be regarded as invalid in accordance with this section, which is section 34 subsection 3 of Companies Act 2016. Next, under section 34 subsection 1 of Companies Act 2016, define a proxy as another person appointed by a member of a company to exercise all or any of the said members' right to attend, participate, speak, and vote at a meeting of members of the companies. Next, section 338 subsection 4, rights of member, termination of appointment. Termination of a person's authorities to act as proxy. Any provision of this constitution is void insofar as it would have the effect of requiring notice of determination to be received by the company or another person earlier than 48 hours before the time for holding the meetings or adjourn the meeting. So the company's constitution may provide for the notice to be given yearly but not more than 48 hours before the scheduled meeting. Next is chairman at every meeting. So there is a chairman. He is in charge with conduct of the meeting, ensuring that it is properly conducted. Under section 3 to 9, the chairman of the board shall be the chairperson, which is the subject to the constitution. If the chairman is not present within 50 minutes or he is unwilling to act at the meeting, so means that other members present will elect other members to chair the meetings. Next, under section 339, under section 336, a proxy can also be elected as a chairman of the meeting. Right to vote is an important right of every members and cannot be forfeited. A member can enter into an agreement with another members on the manner of exercising his vote. However, he cannot do so if it was to oppress their members. Next, there are two basic methods by which votes may be cast by members at a general meeting. A vote at a general meeting may be taken on a show of hands, or alternatively, a vote may be conducted by means of poll. These two well-known methods of voting in relation to companies. Firstly, under section 294 subsection 1, by show of hands, if he is the only proxy appointed by the shareholders, means that notwithstanding anything in the constitution where a member entitled to vote on a resolution has appointed a proxy, the proxy shall be entitled to vote on a show of hands, provided that he is the only proxy appointed by the members. Second is under section 294 subsection 2, which is by poll, if more than one proxy is appointed by such members. So, where a member entitled to vote on a resolution has appointed more than one proxy, means that if the proxy shall only be entitled to vote on poll, and also the appointment shall not be valid unless he specifies the proportion of his holdings to be represented by each proxy.
Okay, I will continue on the resolution. So what is resolution? Resolution means the decision made by the member. Okay, there are types of resolution that you need to know in order to understand the topic of meeting. Okay, the first one is ordinary resolution. Okay, the ordinary resolution is set or is written under section 291 subsection 1, which states that an ordinary resolution of members or class of members of a company means a resolution passed by a simple majority of more than half of such members. Okay, who is the such members? Okay, first, who are entitled to vote and do vote in a person or where proxies are allowed by proxy of at a meeting of members. The second one is the one who entitled to vote on a written resolution. Okay, so to understand the ordinary resolution, let's see the case of Bushell versus Fate on 1970. And on this case, the court held that an ordinary resolution is passed if it is approved by bare majority, that is more than 50% of the votes casted by members present and voting. Next is the special resolution under section 292, which a special resolution of member of a class or a class of members of a company means a resolution of which the notice of not less than 21 days has been given or passed by a majority of less than 75% of such members. Who is the members? Okay, first one is who entitled to vote and do vote in a person or where proxies are allowed by proxy of a meeting at a meeting of a members. Okay, the second one is who are entitled to vote on a written resolution. Okay, number 2, under section 292 subsection 2 says that if a resolution of a private company is passed as a written resolution, the resolution is not a special resolution unless it is stated that it is a special resolution and passed as a special resolution. Okay, under subsection 3, which says that a special resolution passed at a meeting on a show of hands is passed by a special resolution if it is passed or not less than 75% of the member who are present at the meeting. And the last one is a special resolution under subsection 4, which says that a special resolution is passed on a poll taken at a meeting if it passed by the members representing not less than 75% of the total voting rights of the members who are entitled to vote and do vote in the person or by proxy on the resolution. Last but not least is the special resolution of section 292 subsection 5, where a resolution is passed at a meeting on these two conditions. First one is the resolution is not a special resolution unless the notice of meeting include the text of the resolution and states that the resolution is proposed as a special resolution. And the second condition is if it is so stated in the notice of meeting, the resolution shall only be passed as a special resolution. Okay, so let's see the sample of case for the special resolution, which is the first nominee Limited versus New Corp and Realty Sdn Berhad on 1983, which if insufficient notice is given to the members, then the proceedings at the meeting were invalid.
Right? If ordinary resolution required special notice. Under the section 322, resolution requires special notice, where the special notice is required of the resolution under any provision of the Act. The resolution shall not be effective unless notice of the intention to move it has been given to the company at least 28 days before the meeting at which is moved. The company is not required to give notice of the proposal resolution received under the section 1 to the member unless the resolution can be properly moved at the meeting of member required under the Act. The company shall, where practicable, given its member notice of any such resolution in the same manner and at the same time as the given notice of the meeting. Where it is not practicable to give its member notice is accorded with section 3, where the company shall given its member notice of any such resolution at least 14 days before the meeting. By the advertising in the world media, circulation newspaper in Malaysia in the national language and one widely circulation newspaper in Malaysia in the English language or in any other manner as the specified in the Constitution. Next, under writing resolution. Who can propose for a writing resolution? Under the section 297 subsection 1, a resolution shall be proposed as a writing resolution by the board of the any member of the private committee. What can be passed under the writing resolution? Any except as the stated under the section 297 subsection 2 of the Company Act 2016, where under the section 297 section 2 the states where the writing resolution is not allowed. The following should not be the writing resolution as a resolution under the section 206 to move the director before the expired of the term of office, or a resolution under the section 276 to remove an auditor before the expired of his term of office. Next is post meeting requirement. First is under the section 341 section 1, a company must keep or record all resolution of member past otherwise that at the meeting of the member. Next, the minute of the meeting of the member, the details of the any decision made otherwise that by the way of the writing resolution provide to the company with a sole member. How long to keep the record? Under the section 341 section 2, the record shall be kept for at least 7 years from the date of the resolution meeting or decision. Under the section 343, record as the evidence of resolution. The record of resolution passed otherwise that at meeting of member is purporting to be signed by the director of the company or the secretary is sufficient evidence of the passing of the resolution. If the record of writing resolution of the private company, the requirements of this act which respect to the passing of the resolution are deemed to be complied, which at least the contractee is proof. The records of the processing of the meeting of member property to be designed by the chairperson of the meeting or by the chairperson of the next meeting of the member is sufficient evidence of the process at the meeting. The last is section 344. The details of the decision provide the sole member. Where the first is the sole member of the company take any decision that may be taken by the company in the meeting of member and has been effect as agreed by the company in the meeting of member. He should provide the company with details of the decision unless the decision is taken by the authority resolution. Second is a person who the controversy this section commit and offense and shall on the conviction be liable to a fine not to exceed 10,000 ringgit. Other fail to comply with the section does not affect the validity of any decision referred to in the section 1.
Okay, that's all the presentation from us from Group 11. Thank you for your time, your attention, and for lending your ears during the presentation. So if you have any question or inquiries, you just raise the question on the WhatsApp group. So thank you and Assalamualaikum.